afternoon, everyone. Thanks for joining us for today's webinar, Working with and Against Expert Witnesses. This is part 3 of our series on mental health issues in criminal law. My name is Wyatt Fraser. I'm Legal Aid Alberta's engagement advisor. I'll just be helping make sure everything hopefully runs smoothly today. Yes, I do appreciate the heads up from Paul, from our staff member, the Edmonton office. We might be experiencing a fire alarm, so we apologize if any fire alarms come out intermittently. We'll try to best to move through the disruption as it comes up. So on other notes of housekeeping, by default, your microphones and cameras are disabled, but you can engage with us and ask questions using the chat or Q&A feature in Teams. You can click on them by the appropriate icon at the top of your Teams window if on desktop, or at the bottom of your screen if you're on mobile. We ask you to please save your questions till the end, as we will try to have prepared for questions once we get through our slide deck today. If you experience any audio or visual issues, the old adage of turning off and on again usually does work, so we'd ask you to try leaving and rejoining the session, which will resolve most of the issues. If not, send us an email at communications@legalaid.ab.ca, and we'll connect with you to try to resolve the problem there. Please note that we'll be removing any AI note takers from the meeting, but we are recording today's session and it will be available afterwards on our website. Hopefully by the end of this week, we'll send you an email once it's online, along with a copy of the slide deck that was used today. Near the end of today's session, we'll also share a link with you to complete a quick anonymous survey so you can share feedback about today's session. Your feedback helps us plan and evaluate our webinars. So we want to say that we respectfully acknowledge that we are located on the traditional territory of the Blackfoot, Cree, Dene, Nakota, and Saulteaux, lands that are now known as part of Treaties 6, 7, and 8, and the homeland of the Métis. We are honored to live, work, and learn on these lands with all Indigenous peoples as we move forward together in reconciliation. We're fortunate to be joined today by two speakers eager to share their expertise and knowledge with us. So to start, Katie Clackson is a criminal defense lawyer with Legal Aid Alberta's Criminal Trial Group. She was called to the bar in 2013 and joined Legal Aid in 2020. She is passionate about advocating for marginalized individuals within the criminal justice system. In November 2024, she was honored to receive the King Charles III Coronation Medal in honor of her work fostering social justice. Katie enjoys mentoring law students at the University of Alberta's Faculty of Law, Low-Income Individuals and a Law Seminar, and volunteering with the Law Society of Alberta as a mentor to other lawyers and as a member of their practice review committee. Tania Shapka was called to the bar in 2017 and practices criminal law with a focus on trials, appeals, and charter litigation. She joined Pringle Law in 2023 to work with Daniel Song on complex charter litigation, legal research, and appellate work. Tania holds a JD and Bachelor of Science in Psychology from the University of Alberta. She clerked with the Court of King's Bench before completing her articles at a distinguished Edmonton criminal defense firm, where she practiced for several years in both trial and appellate work. She has a particular interest in the intersection of mental health and criminal law and regularly represents clients before the Criminal Code Review Board. Tania is also active in the legal community as a sessional instructor at the University of Alberta, as a member of the Alberta Criminal Trial Lawyers Association, and continue to support access to justice through her volunteer work. And with that, I'll turn it over to Katie and Tania to take things off.
Thanks, Wyatt. So I will just begin by giving a bit of an overview about the purpose of this presentation. So our goal for today is to give you sort of a broad understanding of when to rely on expert opinion evidence and when you might be in a position where you don't need to actually rely on an expert, and what to do when faced with expert evidence, how to approach it, how to challenge it, and what the best practices are when you're faced with it. And so we're going to give you sort of some practical tips as well as an overview of the applicable case law, and hopefully leave you with the tools to be confident when you're approaching this type of case. Our focus today is going to be on mental health specifically, so mental health cases or cases where your client is facing mental health issues, or is being assessed in relation to a specific mental health issue or mental illness. So that's primarily our focus today. There are, of course, numerous other examples of situations where you will encounter expert opinion evidence or where you may be seeking expert evidence, which we are not going to touch on today. Firearms cases, toxicology, SOIRA exemptions, those kinds of things. But our focus today is more so on the mental health space. So one of the first things we want to touch on is the difference between information which comes from an expert versus expert opinion evidence. It's an important distinction. So what we mean here is information from an expert, which is not sort of included within the sphere of expert opinion evidence. That might be information that you receive from a medical doctor, from a psychologist, or some other medical practitioner that your client is working with in relation to a mental health issue, or just even a health issue in general. That is information that you may come by from your client directly, from a family member. They may provide you information relating to a diagnosis that your client has. So you may have doctor's notes, you may have a letter from a doctor or something along those lines. It may be information that you obtain from a mental health court process where you have assigned consent from your client, you've accessed notes from the Recovery Alberta nurses, and they've provided information about your client's diagnosis. That's not expert evidence, right? That's information which comes from somebody who may be in the position of an expert. And that's information that you can certainly rely upon in the course of sentencing, in the course of bail proceedings. It may also be something that's relevant in negotiating with the prosecutor. That's different than expert evidence, which comes from some sort of underlying authority within the Criminal Code of Canada. So how do we use expert information? Within the regular sentencing context, or even sometimes in the bail context, that information can assist you in advocating for a position. So it can assist you in advocating for maybe a non-custodial sentence for your client. It can help you talk about potential risk that your client poses to the community. It informs those sorts of submissions that you may need to make on behalf of your client. Are they a good candidate for more of a rehabilitative sentence because of underlying mental issues that they're experiencing? Are they a risk to the community? Is their mental illness or their diagnoses being managed by a medical professional in the community? And if so, that's something that the court and the Crown needs to know because it's relevant information. So just some examples and how you might use that information. You may know that your client has a diagnosed mental illness or mental disorder like schizophrenia or bipolar disorder. That does not necessarily mean that you're going out and seeking an assessment for NCR. Okay, so just because your client has been diagnosed with schizophrenia and was experiencing the effects of schizophrenia at the time of their alleged offense, you're not necessarily seeking an NCR at that point in time. You're not relying on Section 16 of the Criminal Code. Rather, you're trying to gather information about how that mental illness affected them at the time of the offense and how it might be relevant to the sentencing, or sort of what the goals of sentencing are in the future. Are we concerned about denunciation and deterrence, or are we more concerned about rehabilitation? Often that information will militate in favor of a non-custodial sentence because you want to see your client getting the treatment in the community that they need to ensure that they don't commit further offenses.
And just as somebody who,
sorry,
Katie,
Tania.
as somebody who practices before the review board quite a bit, I think this has been emphasized in some of the previous sessions, but, as Katie said, you want to be very careful before jumping to an NCR defense because it has very significant implications for your client in terms of potentially being detained in the hospital indefinitely when they would serve their sentence and be finished in a much shorter period of time otherwise. So it doesn't mean that this information can't be helpful to you in sentencing or can't be useful to you, but you want to think carefully about the purpose for which you're using that information.
Exactly. So keep in mind what the consequences are of even if you think, I would like to get an assessment for criminal responsibility and just see what comes of it. That's not the approach that we would advise that you take. If you're considering an NCR defense for your client, I would I think we would both strongly advise that you reach out to senior counsel and talk to lawyers who have experience to see what they would advise. Is it in your client's best interest? And get that information before you make that decision. There are other sort of underlying conditions that are mitigating in sentence. So one that we commonly see, certainly in the mental health context, is FASD, which is a cognitive disorder, or learning disabilities, other cognitive issues like ADHD. Sometimes when you're dealing with an adult client, they may be telling you that they have some sort of diagnosis, or maybe they've been found to have ADHD as a child. If you can, I mean, you want to ask them, did you have a psychoeducational assessment? Easier sometimes with a youth client because they're sort of in closer proximity to those types of assessments, maybe through school. And so you might have an easier time accessing some of that information. But I would strongly encourage you to try to get at that information through family members, through your client. Do they have a treating physician who may have some of that background documentation? And if so, have your client sign a consent form to allow you to access that information, because it is extremely helpful. You want to be thinking about, okay, what is their treatment plan? What is the treatment that they're currently getting in community, if any? Who is involved with that treatment? What does that treatment look like day to day? Does it involve an injection? Does it involve an oral medication? How often are they seeing their doctor? Who else is part of the treatment or the care of your client? And what progress, if any, have they been making as part of that treatment plan? Are they making good progress? And if so, that's information that you want to bring forward to the court as well. Tania, I don't know if you want to jump in again here, but feel free to jump in anytime.
I will.
So this all matters because mental health issues reduce moral culpability. So the Court of Appeal has been very clear throughout the years that mental disorders it's not just a case of, okay, you have an NCR defense or nothing. Mental disorders are mitigating on sentence. So we have the AORIC decision from 2012 where the Court of Appeal said that mental disorders, particularly schizophrenia, can significantly mitigate a sentence. And the relative importance of deterrence and denunciation is attenuated when sentencing mentally ill offenders. So it's important to keep that in mind. That's really the sort of overarching principle when you're dealing with a mentally ill accused. It matters because it actually will impact their sentence at the end of the day. And not just their sentence, but also their prospects of rehabilitation. We go forward to 2020, and in the Roberts decision, the Alberta Court of Appeal takes it a little bit further and says, we're not just concerned about mental illness such as schizophrenia, we're also concerned about cognitive deficits flowing from fetal alcohol spectrum disorder. So by 2020, the Court of Appeal has a bit more understanding that FASD is a common illness that many people who come into contact with the criminal justice system are experiencing. And the impacts of that are real, and we need to address them in sentencing. It is mitigating, and it needs to be brought forward because it's reducing the moral culpability. So one of the things that we want to be thinking about whenever we're handling a case with a mentally ill accused is, do you need an expert? So maybe you've gathered some of this information and it's sort of satisfied you, and it has given you a lot of the good information that you need to put before the court, to put before the Crown, to help you in negotiating. There are, of course, times when you do need to go further and you need to seek an expert to support the submissions that you plan to make in court. I think both Tania and I, we discussed this sort of in preparation for this presentation, that in the vast majority of cases, we're actually not seeking experts. Okay, so we're actually not seeking expert opinion evidence when dealing with a mentally ill accused. More or typically we're just gathering information on our own from our client, from other sources, and putting that before the court. But you need to think about, okay, do I have enough? Are there questions that I still need answered? Are there questions that I'm just not getting the answers to, or that I'm just, I remain unsure of something, even after the information gathering? So sort of the way we want you to think about this is, okay, so now say, for example, your client has been assessed for fitness. Okay, so whether that's a concern that you have, the Crown has, duty counsel has, the judge has, somebody has raised the issue of fitness. Now your client has been assessed for fitness and probably by a forensic psychologist, and they have come back and said that your client is unfit as of that moment. As you're reading that kind of report or any kind of report in the mental health space, there's a lot of sort of medical jargon that you may not understand, right? And that's okay. You're not a doctor. You're not expected to understand all of it. You may have to educate yourself on what is actually being said. So our advice is to reach out to senior counsel, review textbooks, educate yourself, get an understanding, because that will help you determine if you actually need to bring in your own expert. And the other thing I would say is, you can be a bit creative when you have a situation where maybe fitness is an issue. I've had and you're sort of worried that, okay, well, my client is probably unfit. What does that mean? Are they going into the hospital? Like, are they going to be moved from the remand center into hospital? Here in Edmonton, that's Alberta Hospital Edmonton. We also have Southern Alberta version, or Southern Alberta Hospital. The name is escaping me right now, but in any case, so are they going into sort of a secure forensic facility? What is that going to look like for them? So those are questions that I personally, my approach to this is, even before I go into a fitness hearing, I like to talk to whoever has assessed my client. So I actually will have a phone call or an ante-room meeting with whatever doctor has assessed my client. And I will say, practically speaking, what does this mean for my client? Where are they going to go? Those are things you're allowed to do. So don't be afraid to have a conversation with the doctor or the psychologist before you get into a situation where you're suddenly having to cross-examine them, okay? I find that they're very willing to talk to defense counsel about, practically speaking, what their determination means. I've even had a doctor reach out to me on her own and just say, look, this is what I'm thinking of finding. What do you think about it? From your perspective, what is that going to mean for your client? Which I think tells you that, first of all, these are physicians and, these are practitioners who care about what happens to our clients. Maybe not in every case, but in many cases, right? They have compassion and understanding and empathy. And so they actually do have concern for the client and where they're going to go. And so don't be afraid to have those conversations and say, my client seems to be doing really well at the U of A on the psych ward, and they have really good support there. Can they just stay there? And I've had situations where the doctor will say, yeah, sure, that sounds good. We think we can get them fit where they are. We don't need to move them to Alberta Hospital. So, but those are conversations that you are certainly able to have, and we would encourage you to have. Tania, I don't know if you have any other suggestions there.
No, I would agree with that point, though. There's no property in a witness. So even if this is a case where that expert is going to be called as a Crown witness, there's certainly no issue with you reaching out to that witness to contact them, maybe float some questions that you might have so that you know what the answers might be before you go into cross-examination. Just like Katie, in my experience, the experts have generally been quite willing to speak with defense counsel. If you don't have their contact information, you can ask the Crown, and it can be beneficial for you in your preparation.
Yeah. And then, okay, so now you think, okay, maybe I want to actually retain my own expert. Where do I go? How do I do this? What is the process? So unfortunately, there's no sort of repository for this information at this point in time, at least not that we're aware of. So it does require some legwork on your part. Ask your colleagues, ask around. use your listserv connections, rely on people. But in particular, you want to speak with people that you know have experience working with the type of expert that you are seeking on your specific type of case. And do some research, right? So reputational research on the expert that you're thinking of retaining. Do a CanLII search, see if they've been, if their opinion has been relied upon elsewhere or not, right? If they've been sort of found to be not an appropriate expert, or if their qualifications have been challenged, or if they've just generally found not to be credible in their opinions. Because you want to be bringing forward an expert that's going to support your case, your position, in a way that is, the most effective. And so you don't want the Crown sort of poo-pooing your expert. You want somebody who has a good reputation with the court. Now I'll turn it over to Tania, unless anybody had any questions just sort of on those specific points. Or I don't know if we're taking questions at the end, Wyatt, but maybe
It's your guys' preference. So Shazia did have a question that might pertain.
Okay.
So just to read out. So I have a case where the Crown has refused to accept my client's medical records as mitigating evidence. How can I introduce my client's medical records as mitigating evidence and ask the justice to consider them during sentencing despite the Crown's objection?
Right. So I guess what I would say is it depends how you've come by the medical reports. I'm going to assume for the purposes of the question that you've obtained them through consent from your client and that you've gotten them directly from a doctor's office. If not, then you probably need to do some additional legwork in order to sort of substantiate or validate the information that you have. But let's assume that you already have what you've found to be valid information. I think I'd probably start by just sending them some of the case law that we have in this presentation and just ensuring that they understand why you're trying to rely on the evidence. But it does need to be relevant. So, you want to look at it closely and ensure that what you're relying on is relevant to your particular case. So you may want to sort of tailor it a bit more. You might want to be a bit more narrow in what you're trying to present and make sure that it actually does tie directly to the argument that you're trying to make. Tania?
Yeah, and I would add, it also depends on the type of the information. If it is just something like maybe a discharge summary or a hospital report that's basically summarizing factual information, you may simply be able to enter it as an exhibit on sentencing. If it's something more detailed in terms of an opinion about your client, it may get into the expert evidence provisions that we're going to talk about, which would then require you to potentially call the treatment provider to provide that opinion if the Crown is not willing to sort of accept their report for whatever reason. And you can also have some back and forth with the Crown, ask them to identify what their concerns are. Maybe it's that they think there's some irrelevant information that could be vetted out. Maybe it's that they think that the opinion is something that they want to challenge by having the expert testify. And then we'll deal with the expert evidence provisions that I'll talk about now. Yeah. So just in terms of the difference between expert opinion evidence and this is probably a nice tie-in in terms of just factual evidence. An opinion is an exception to the normal rules of evidence. It's only in certain circumstances that we're allowed to have the trier of fact rely on opinion evidence in court proceedings. One of those exceptions, as everybody knows, of course, is expert opinion. And sometimes it's hard to distinguish between what is actually a fact and what is actually an opinion, particularly in something like a medical sphere where we have, a fact of a diagnosis or certain observations that are made in the hospital. And so generally, when you think about opinion evidence, we're thinking about something that has an inference or a conclusion or some sort of impression that is drawn from facts. So it's not just observations, but it's something more that is being interpreted from those observations. And of course, an expert opinion requires somebody with specialized knowledge and training in a particular area of expertise to provide evidence to the court that's outside the ordinary experience of the judge or the jury. So it is important, of course, to know that if you intend to put forward opinion evidence in a proceeding, that there are notice requirements in the criminal code. You can look at section 657.3 for the full requirements, but generally 30 days before the start of trial, you have to give the name of the expert, their qualifications, which is usually their CV, and the proposed area that they're going to be testifying in, or that you're going to ask the court to allow them to testify in. Because we always need to make sure that we are stating the area of expertise of proposed opinion evidence with some definition. Because just because somebody is qualified as an expert to give evidence on risk assessment doesn't necessarily mean they're qualified to talk about everything in the field of psychology generally, or any opinion that they want to offer about your client or the case. So the way that the expert qualification process works is going to define that area. One of the few exceptions to defense having to provide disclosure to the Crown, obviously in most cases we have no obligation to do that, but the expert notice provisions do require disclosure of a report or the summary no later than the close of the Crown's case. Typically, if there is a failure to disclose, that'll just result in an adjournment, but ultimately you do have to comply with those provisions, and the judge is going to decide what to do in the event that those notice provisions aren't complied with. I'm sure everybody is also familiar with the Mohan criteria for qualification of an expert. But just as a review, before an expert is allowed to give opinion evidence, there will be a voir dire where the judge will hear about their qualifications and decide whether or not that expert should be allowed to give opinion evidence. And ultimately, it is the trial judge that makes that determination of whether this is an appropriate expert or not, even if counsel are in agreement. There's the threshold requirements that have to be considered first: relevance to an issue in the case, whether the evidence is actually necessary to help the trier of fact as expert evidence, or is this something that the jury can assess on their own without the need for specialized knowledge and training. You have to ensure that there aren't any other rules of evidence that the proposed expert witness would run afoul of. And then, of course, that the expert is properly qualified. And so this includes two aspects. The first is obviously their training and experience. And, you want to consider where they were educated, what their field of expertise is, how they were qualified, whether their training and expertise in the area that they propose to testify on is recent, if they've kept up to date in their field, things like that. But there's also a threshold requirement that the expert is independent and impartial. Ultimately, they're there to assist the court. That is a low bar at the threshold stage, as we'll talk about in a moment, but that is one of the threshold criteria. And then ultimately, the trial judge is also required to weigh the probative value of that evidence versus the prejudicial effect. So, considering things like the length of the proceedings, if we have expert evidence, if there's any risk that the jury would be distracted by the expert evidence, or if it would overwhelm the jury, other impacts on the fairness of the trial versus how helpful or reliable the expert information is. Katie, do you have any comments on those threshold criteria?
I do not. That was brilliant.
Then just to go a little bit more into a case called White Burgess that I'm sure you've also all heard of, but it does really go much more into detail about that duty for the expert to be impartial. And at the threshold stage, as I mentioned, it is a pretty low bar, but bias and impartiality can also be dealt with in that weighing that the trial judge has to do about the probative value versus prejudicial effect. So you want to consider in the qualification voir dire and in researching your expert whether there are any concerns about impartiality. I personally haven't ever had a situation where an expert has been found to be biased or partial so that their evidence was excluded. But some circumstances that I might think of as an example, I know at one point the behavioral assessment unit, the detectives that worked with EPS were doing some risk assessments of individuals for 810.2 peace bonds. I would maybe have some concerns there and want to explore that on the voir dire. Similarly, some of you might have heard about the De Ruyter case in the news. It was ultimately stayed, but information that I've heard from counsel on that case, Dina Batos and Zachary Al-Khatib did excellent work laying a foundation for White Burgess concerns that the expert may have been incorporating suggestions from the Crown into their report and revising the report to be more inculpatory for the client, or to be more to make the client look worse. And so that would be something that you might be able to, if you think that's occurred in your case, request disclosure of drafts to try to show that there is some sort of bias that the expert has because of the party who retained them. As I said, it is usually going to be rare that expert evidence will be excluded on that basis. Most experts really do understand that role, and they'll say early on in their testimony on the voir dire that they understand and recognize their duty to be impartial, but something to be aware of. So the qualification voir dire proceeds where the party who is trying to have the expert witness qualified will identify that proposed area of expertise with some specificity, and there will be a voir dire. It will go into the expert's qualifications, usually the Crown, or if it's defense trying to have the expert qualified, you'll go through the CV and their relevant experience, whether they've been qualified in the past, although that's not determinative, and also some questions about their impartiality. Even where the parties are consenting to the expert being qualified in a particular area, oftentimes, in my experience, most judges will still ask for an abbreviated qualification voir dire, because at the end of the day, it is the judge that has to exercise that gatekeeping function. So they want to have the highlights, so to speak, of the expert's qualifications to satisfy themselves before they are admitting that opinion evidence. And then just a reminder, also some basic principles about expert evidence. This may come up less frequently in the context that we often see opinion evidence in mental health cases, because in many instances, we're getting expert evidence in maybe the sentencing context where the rules of evidence are more relaxed, or on peace bonds, those preventative applications where we're actually looking at a standard of a reasonable fear that somebody will commit further offenses. And so there's different evidentiary rules. But there does have to be a factual foundation for the expert's opinion in the normal course. And so just keep this in mind. You know, for example, if you have an opinion that your client is not criminally responsible on account of mental disorder, and a large part of that opinion is founded in certain actions of your client at the time of the offense or after the offense, you want to make sure that the witness that made those observations either testifies to that in the trial, or that you have an agreed statement of facts that covers off that information. So, you know, just think about what the foundation for the opinion is, either as the party that's calling the expert and wants to make sure the evidence is before the court, or as defense counsel challenging a Crown opinion, trying to undermine some of the factual foundation that the expert might have relied upon. And we'll talk a little bit more about that in a minute when we talk about expert opinions and how to challenge them. So Katie talked a little bit about, you know, researching your expert, reviewing the report. And when you have an expert, on the one hand, it's a challenge because this is a field of study that you didn't go to school for in all likelihood, and you're going to learn some new terms. You're going to have to do a lot of research on your own to have at least a working understanding to be able to have an effective questioning of the expert, whether indirect or cross-examination. But with an eye to expert opinion evidence, some of the best advice we can give you is to put in the legwork to do your research. So it's good to find out information about the expert themselves, as Katie mentioned. You want to get a baseline knowledge of the field of expertise. If there is a specific risk assessment tool that was used to assess your client, we'll talk generally about risk assessments in a few minutes, but you know, things like journal articles from a psychology journal about how that test was developed, or studies that have been done on the validity of that tool since it was developed can be helpful to give you ideas for cross-examination or questions to ask the expert, limitations of the tools. Sometimes in these cases, the manuals that the experts use are proprietary or subject to copyright, so you may or may not be able to access a copy of them, but usually things like at least the scoring sheets or charts will be available to you, and you can usually find quite a bit of information online about a particular risk assessment tool that will give you at least a working knowledge to be able to ask some informed questions. At the same time, I would say be cautious about getting overconfident based on your research. If you think that you have a big gotcha moment, that the expert missed something huge, don't just run into the courtroom and start asking them those questions. Take a moment, ask yourself whether it's possible that maybe you have missed something because you don't completely understand the field of study. It could be that the expert mistallied their scoring sheet, or, I did have a case once where the expert relied on youth convictions and the manual said they weren't really supposed to, although in that case, the expert did realize that before they actually testified. But, you want to just make sure that you're not being overconfident. And this is where sometimes retaining your own expert can be very valuable. I have in some cases sought authorization or had my client pay for an expert to just essentially review an expert report and give me a brief critique of it. What do you think the holes are in this? Do you have any questions that you would suggest I ask? And where you can, it's obviously not feasible in a lot of cases for practical constraints, but where you can, that can be really invaluable in preparing your cross-examination, or even, just answering a very discrete question for you on a topic that you're not sure of. And again, your colleagues are a good resource if they've dealt with a similar type of assessment, a similar type of case. But you will have to do the legwork to try to get that background information. The other thing to mention is that when you're reviewing a report, you want to also review it with your client. Of course, that seems obvious, but your client may say, this paragraph that summarizes the interview misstates what I said. There's something inaccurate there. Sometimes in these reports, information gets copied and pasted throughout the client's history. And so if there's a mistake in a report early on in their course in hospital or in correctional records, that might get pulled through into the report that you get more recently. And so it's important that you have all the information that you need in order to challenge any inaccuracies in the report. And so that includes making disclosure requests for any information that you're missing. If there was some sort of psychological assessment done, like a risk assessment, the report should come with the scoring rubrics. You should get the experts file review notes. If they looked at, in dangerous offender applications or 810.2 PSPONs, they'll often go through all of your clients' correctional records. So you need to make sure that you have those records so that you can see whether the expert summary was accurate or not. And in some cases, you may have to make an O'Connor application if the Crown doesn't have those materials and won't bridge the gap to try to get them for you. But it is important that you get all those background sources, other reports that the doctor may have reviewed. If there's a different expert that assessed your client for a neuropsychological report, you want that report to see what it says and whether the expert that's going to be testifying interpreted it or summarized it accurately. And, as Katie mentioned before, when you're preparing to challenge an expert report, there is no property in a witness. And so it can also be helpful in some cases to speak with the expert ahead of time. On the one hand, that's a judgment call you have to make. There may be practical or tactical reasons that you don't want to give them a heads up about certain areas of cross-examination or things that you might challenge them on. But at the same time, in some cases, it may be helpful for you to explore certain things with the expert before you are having them on the stand. So in terms of potential areas of challenge, there are a lot. We've thrown out some on the slides in terms of the various areas of the report that you might be able to think about when you're reviewing a report, and whether there would be any fodder for cross-examination in these areas. You know, we talked a little bit about qualifications at the qualification stage, but think about when they did their training. Is this somebody who's moved areas and all of their risk assessment training was actually 20 years ago and now they're being asked to do risk assessments again? How have they kept up with the literature in their field? I think we already talked about impartiality, but something to think about. When you're examining the expert, they should be prepared to concede reasonable points that might be in your client's favor. So don't hesitate to try to elicit helpful information that you might be able to use in argument later. You can make sure that the expert is staying within the bounds of that scope of qualification and object to questions or evidence that starts to bleed into the margins of their area of expertise. You know, for example, if somebody was qualified in risk assessment, but they're not a clinician, they don't have experience treating individuals, and they were qualified in the area of risk assessment specifically, it may not be appropriate for them to comment on what they think is effective treatment. So you just want to be mindful when an expert is testifying of what those areas are, and keep that to what is designated by the judge in the voir dire. We talked about the factual foundation, and so something that can be really effective in challenging the expert opinion evidence is to chip away at the foundation for their opinion. So, you know, for example, in peace bond litigation, an expert report may rely on a lot of uncharged conduct that police have investigated, but there weren't enough grounds to actually lay charges or for the matter to be prosecuted before the court. And so if you can raise concerns about the factual foundation for some of those allegations, you know, whether it was actually your client, whether there was actually an offense committed, but the expert has relied heavily on those in coming to their opinion, you might be able to undermine the foundation for the expert's ultimate conclusions. There may also be situations where your client's circumstances have changed. You know, in many cases, a client might decide not to cooperate with a Crown expert. And so there's a lot of information you might have about your client and the things that they have done since the time of the offense that would change an expert's assessment of risk. And so you can put hypotheticals to the expert to see whether their opinion would change if they had known that additional information. You know, make sure that in your cross-examination, you're thinking about what information you can elicit from the expert to help you argue about what weight the judge should give to the opinion ultimately. You know, ask them about limitations of the tools. You can put to the expert some of the research that you've done about limitations. And on occasion, you can also ask a well-placed open-ended question. You know, are there any other limitations that I haven't identified that you're aware of in relation to this tool? You know, is there any other information that was missing that would have been helpful to you in your assessment? So identifying gaps in the report can be helpful. You know, there are specific processes if you identify some psychological literature for cross-examining an expert on a text or article that they say is authoritative. Although if they do not recognize that source as authoritative, you may be stuck in terms of being able to ask them questions about their resource. And then, you know, the other thing to think about when challenging an expert opinion is, of course, whether you want to find your own expert to potentially present a different opinion. Many experts acting reasonably in their field will have different opinions about somebody just because of their, you know, processes, the way they do things, their clinical experience. So it may very well be that just because one expert thinks your client has a certain diagnosis or is a certain level of risk, you know, there's no guarantee that a second expert will agree with that. So in some cases, getting a second opinion may be valuable. Katie, do you have anything to add about other areas people might want to consider when they're reviewing a report and thinking about what to challenge?
I think just to touch on what you were just talking about, which is, think about your client, right? And do they require maybe more of a trauma-informed approach? Is there potentially cultural issues? Is the person coming from a background where they may have experienced trauma? Have they been a refugee? Like, these are considerations that play into their willingness to provide information. Like, what's their understanding of what's being asked of them? And sometimes those factors are part of the risk assessment. But really, you want information from a clinician or an expert who is aware of some of those underlying issues and able to, sort of like they have to, or they should play into the opinion. So if you have, I have a file right now with a young person who's in custody and has a background, coming from very difficult background as a refugee. And we intentionally selected a psychologist who could assess him and would take a trauma-informed approach, which is important when you're dealing with mentally ill clients who have other underlying issues in addition to mental illness or, other cognitive issues. And through that process, you may find that there may be even more going on than you actually realize. So you may recognize that your client has, maybe cognitive delay, but you don't know what's really going on. Well, it turns out that they suffered a brain injury as a child, or they have a seizure disorder, or there are other medical issues that are happening. So, the point is that some experts are better than others in getting at that information. And again, I mean, this is where you need to assess whether or not to bring in your own expert who may take the time to not only meet with your client, but meet with their family members, get that background information, which helps them do more of a fulsome assessment and, have a better understanding of where they are placed sort of on the spectrum, but also what is their risk in community? Do they have family support, right? Those sorts of questions. So that would be my suggestion, is to think a little bit more broadly about it. In terms of the information you're being given.
And that's an excellent point, and I think a really valuable point to consider when you're thinking about what might have gone into the Crown report coming out the way it did, and whether there's additional information or additional considerations that might make your own expert something that is valuable in the process. I'm going to talk a little bit about risk assessment tools because I think it is helpful to have an overview of what they are. I will say I'm not a psychological expert. I have some understanding of these tools by, seeing them throughout my practice. But, I by no means am the authority on this. And a lot of these are very specific to the particular instrument that the clinician is using to assess your client as well. So we certainly can't cover all of them in the presentation today, but we just want to give you a little bit of an idea of what they can look like and some things to be aware of in terms of some of their limitations that you might want to delve into more if you have a file with a risk assessment and need to have a jumping off point for how to challenge that. So essentially, what risk assessment tools are a psychologist is assessing your client. They're trying to sort of predict what their risk will be to commit further offenses upon release or after sentencing. And there are three broad types of risk assessments. The first is unstructured clinical judgment, which is essentially just the psychologist or psychiatrist forming an opinion based on their training. They get to decide what inputs they consider, what information they think is relevant. There's really no guidelines. And evidence I've heard from doctors on the stand has been that really the research says that these unstructured clinical judgments are pretty poor at accurately predicting risk. Maybe at best it's like flipping a coin 50-50 in terms of how reliable they are. And of course that makes sense. Inherent biases may come into play. It will vary a lot from clinician to clinician. So if you have some report that relies on that, unstructured, free-form assessment, you may have some concerns and want to delve further into how reliable their opinion is on that basis. Then we have actuarial tools, which are very formulaic. Essentially, it's like an algorithm. There's certain inputs that get scored on a numerical basis, and it gives your client some sort of risk score or band in terms of moderate risk, high risk, very high risk. And there's very little room for the clinician to exercise their judgment in terms of how those items are scored. And the best way to explain actuarial tools, I think, is an example I heard a psychologist use, which is insurance companies. So they might, as an insurance company, they're trying to assess how much to charge people as premiums. They're trying to assess your risk as a driver. So they'll look at the probability that a driver with certain characteristics will behave in a certain way. And so, if you take a Venn diagram, essentially what insurance companies do is they look at people who drive in red cars, people who get in accidents. They look at how close that overlap is on the Venn diagram, and the greater the overlap is, the more likely they're going to think that somebody who drives a red car is likely to be in an accident. And so the premiums for people who drive red cars might be higher. It's important to understand that this is correlation and not causation. So simply because you drive a red car doesn't mean you're going to get in an accident. Similarly, the psychological tools that are actuarial tools will do a similar thing. They'll do a statistical analysis from different variables, like the age at your first sexual offense, adverse childhood experiences, exposure to substance use, whatever background factors. And they'll find the factors that are most strongly correlated with people reoffending, and then they'll put those factors into the tools. So again, it's correlation and not causation. So, limitations of these tools is that, they are quite rigid, as I mentioned. So even if a scorer thinks that, for example, this person's particular first offense shouldn't count for some exceptional circumstances, they don't really have the discretion to eliminate that item in the scoring rubrics in most cases. And also, they don't take into account dynamic factors, which we're going to talk about in a moment. So dynamic factors in many cases will make a big difference. They're factors that change over time, whereas static factors are some of those inputs into these tools that are things like number of convictions. You can never change that. It can only increase. You can't go back in time and erase convictions. So static or historical factors are not changeable. Dynamic factors are things like treatment progress, stable housing, things that can change and evolve over time. In most cases, although it's not always the case, a lot of the actuarial tools like the static 99R, which is one of the commonly used ones, will often just look at static factors. And so you can see how there would be a big difference between somebody with a high score on this actuarial test, but has, let's say, stable housing. They've gone through intensive treatment at the Rocky Mountain program for sexual offending. They have a plan in place about how they're going to stay sober, as compared to somebody with the exact same numerical score on that risk assessment tool who has not taken treatment, has an unstable environment, and so on. So the last form of assessment is a structured professional judgment tool. An example of that would be the HCR 20 version 3, which is used quite commonly. And this is kind of in between those two types of assessments that we just talked about. So it is a more systematic evaluation of risk factors. There's specific categories that the clinician has to look through, but they still get some discretion in terms of how they weigh the variables and their significance. So we've talked already about some of the limitations of risk assessment tools in terms of those tools that primarily focus on static factors. So they won't take into account your client's progress. There's nothing your client can do moving forward really that might change their score, other than maybe in some cases aging, because there is some evidence that after a certain age, after age 40, males in particular tend to have lower rates of reoffending. But There are other things to be aware of, and there's two decisions here. In particular, if you have an Indigenous client that's being assessed using some of these tools that you'll want to look at, because there are special considerations when, in terms of cultural considerations, and also the impact of colonialism and how they're affecting Indigenous accused people who are being assessed using some of these tools. So there are concerns, number one, about whether these tools have actually been validated on populations that include Indigenous persons. And so in a lot of cases, when these tools are being developed, there's a certain research group that's being used to study and develop these tools, and it might be from Europe, it might be from North America, but not include Indigenous accused people, or it might include a proportion of Indigenous accused people that's lower than the normal rate. So there are concerns about whether these tools are actually as accurate for individuals who are Indigenous or maybe have a different cultural background in the sample population. The other thing to be aware of is that colonial impacts actually can lead to higher scores on risk assessments. And the case in Nijmegen does talk about this at some length. You know, there are many inputs in a lot of these tools that are a direct mirror of a lot of the GLADU factors that we bring before the court. You know, adverse childhood experiences, early exposure to violence, early exposure to substance use. You know, people have a higher rate of conviction because of over-policing of their communities. And so there's this vicious cycle where, you know, individuals are brought before the court, there's a risk assessment done using these tools, and these underlying factors penalize those individuals on these risk assessments, which then leads to over-incarceration and longer periods of incarceration in the sentence that they're going to get, or, you know, a dangerous or long-term offender designation. So be mindful of these. That's something you may want to draw out information about in cross-examination and make an argument, because at the end of the day, you know, a risk assessment tool is not a crystal ball. It does not predict the future for your client. And you have to make submissions to the judge about how to situate that particular risk assessment in the context of the entire case. There's always a tendency to overestimate risk. So part of your job in understanding and challenging these risk assessment tools is to highlight the limitations, is to highlight how these tools may disproportionately impact Indigenous accused people, and use that to your advantage in your sentencing submissions or whatever submissions you're making in your particular matter. Katie, do you have any comments on that?
I think what I would say is, like, listen, Nijmegen wasn't that long ago. That was still a relatively recent decision. So the court is developing an awareness now, but you should still plan and be prepared to argue this point and advocate on this point, because we know from experience that it takes a while for this information to sort of actually trickle down into the lower courts in a meaningful way. And so you should sort of arm yourself with that knowledge and information and be prepared to make that argument, because I would not assume that a justice sitting in a lower court necessarily knows how to apply that sort of thinking when they're looking at an expert report. So just sort of practical advice. Yeah. Sorry, go ahead, Tania.
No, go ahead.
I was just going to launch into the next part unless you had any other comments, or unless we have any questions. Just trying to be mindful of time.
Yeah, and I think we can address maybe other questions at the end. I agree. We can move on to talking about working with your own experts. You may decide for whatever reason that you think it's important to retain your own expert, either to give a conflicting, hopefully a conflicting opinion, maybe get a different perspective, or, maybe to help you evaluate the opinion that you have. And I'll just, one thing I meant to mention earlier was that, for a lot of the structured professional judgment tools or other types of assessments, it can be quite a bit of variation between clinicians in terms of how they interpret certain items. So in those cases, it may be beneficial for you to get a different perspective.
So, just some sort of practical considerations for you when you're deciding whether or not to proceed with retaining an expert. Sort of reviewing the expert opinion evidence that you have before you, which has come from a Crown witness, or which maybe may have come from a practitioner in a sort of court-ordered assessment. What are the issues that you're trying to get at? What do you need more information on? So you need to be really clear in your thinking about what questions you need answered. Why are you seeking an expert to help you? What type of expert are you looking for? If you have a report from a forensic psychologist, you're probably looking for your own forensic psychologist. Is it maybe information that you need to bear out from a medical doctor? Like what is it that you're trying to get at, and what are you going to use it for? How does it assist you? So you need to be very clear in that thinking in terms of what it is that you're trying to get at. Again, this may involve, like Tania said, maybe you're having sort of a pre-consultation with a would-be expert and saying, here's my situation. What are your thoughts? I've certainly done this, had a bit of an informal phone call with a forensic psychologist that I trust and who I know does good work. And I'll say, this is the situation. It's a dangerous offender, whatever it may be. Here's what we have. What are your thoughts? And they might say, well, it sounds like what you're telling me is, likely sort of the right kind of thinking, and they went through the right processes. And, maybe I wouldn't recommend you proceed with retaining your own expert. So you can get advice that way without sort of going all the way to actually retaining an expert. And again, just reiterating the importance of talking to colleagues, phone a friend, don't be afraid to bring in senior counsel, and meet with your client and have a conversation about it and get their instructions. One thing to consider is if you actually decide to retain your own expert, it's one of the sort of the great things about that is whatever comes out of that is information that you retain, you keep unless and until you decide to share it. So because it's come to you by way of an expert that you have hired or retained, you can have a look at it. You can decide if it benefits your case or not. So that's sort of one of the benefits, is that you have control of that information and you can decide how to use it, versus the situation where a court-ordered assessment has been made. Whatever information comes back is going to the Crown and the court, and you have no control over it. You can't stop it from going before the judge. Tania, I don't know if you had any other sort of suggestions on that.
No, I think that's a good broad advice for people.
We're trying to keep it broad now because I don't want to run out of time. So on that note, we have a clip from Ian Runkle with the Legal Aid Assessment Team, who has done a video for us on just advice on how to actually get your authorization requests for your expert approved. So just some helpful tips here. So Wyatt, I'm just going to play this video, hey?
In theory,
okay?
That's all you should need to do.
Okay.
Hello, my name is Ian Runkle, and along with Debyani Sarkar, we are the criminal assessment team at Legal Aid. So we're the people who either hit approve or reject on your authorization requests. I'm here to help you get a few less rejections on those expert requests, so let's dive in. The first thing, and this is kind of the overarching thing, is the test Legal Aid applies, which is, would a reasonable person of modest means funding their own defense expend this money? And it will help you out if you consider that and possibly even directly address it. Why would a reasonable person of modest means funding themselves spend this money? The more money you're asking for, the more you may have to justify it. The same way you'd have to do with a client who is sitting in your office opening up their own wallet. If you're saying, here's why we need this money for an expert, you're going to want to explain why this expert is important, what they're going to do, how they're going to help. The next thing is that the legal aid rates are capped. There is a hard cap, and it's found in Admin Policy 5. It depends on the type of expert. But if your expert is demanding a rate that is higher than that, you will get a rejection. 100%. There is no discretion here. It doesn't matter how much of a sob story or how much you need it. You can make us feel bad for rejecting it, but you can't make us approve it because this is a hard cap without any discretion. So be mindful of those caps. It's a very common reason for rejection. Other common mistakes: failure to include a CV or invoice. If there's not a CV and an invoice/estimate, then it will get bounced. This has to be on every request. Doesn't matter if you've used this expert before, doesn't matter if they're a really common expert, has to be on every request. The next one is failure to provide an hourly rate. We can't do fixed rates. We've got a cap, and so the expert's got to break down into an hourly rate, and that has to be under the cap, or else it won't be approved. And the last one is failing to explain why the expert is needed. We get a lot of requests that just say something like, we need a computer forensic tech. Okay, why? What are they going to get you? Like, how does this get you to an acquittal or a lesser sentence? Why is this expert important? How do they justify their fees? If you keep all of those things in mind, you're a lot less likely to get a rejection, a lot more likely to get an approval, and to be on your way helping your client. So thank you, and back to the presentation.
So obviously very thankful to have Ian's advice, especially because he is a YouTube star in his own right. And was kind enough to make that video for us. One thing I will actually just add to what he said is when he says that you have to submit a CV every time, that means even if you have submitted a request, a day before that was rejected and you're now providing additional information, you need to go through the entire process again of submitting CV, invoice, the entirety of the information needs to be resubmitted. So it's not just going back and adding one sentence, it's actually redoing the entire auth request again. So just last couple of points here. I'll let Tania maybe take this part and then I'll maybe jump in as well.
And so we'll try to leave a minute or two for questions and just highlight a few things you might want to consider in the process of retaining an expert. We've kind of set up a life of how that might go in 10 easy steps. I'll highlight, it is my practice generally to send a letter of engagement to the expert. You want to put very clearly in writing what you're actually asking them to investigate. I would always want that to be an open-ended question. The White Burgess factors are going to apply to your expert just as much as they apply to the Crown expert. And so if you're saying, please provide a report showing that my client has lower moral culpability, that's going to come out in the cross-examination of your expert or maybe even in their report. It's much more effective if you just ask for a general assessment of any factors that might bear upon your client's moral culpability. As we mentioned, obviously your expert report is going to be confidential. It's protected by litigation privilege. You will also need to share Crown disclosure in most cases with your expert, or trial transcripts, agreed statement of facts, those sorts of things, so that they have all the relevant information they need about the allegations to help them come up with a fulsome opinion. Just double check your Crown disclosure obligations in terms of your undertakings. In most cases, that's included as part of, actions that you're taking to further your defense. I've even seen, in specialized prosecutions, a lot of the specific conditions that they have do allow for an expert explicitly. But just make sure that you've covered your bases off there. And in many cases, you may need to ask your expert to return the material to you at the conclusion of their retainer or conclusion of appeal periods on the file, or just destroy it or have certain protections in place if they're viewing material on a computer. Do make sure that you give your expert all the material they need, but not what they don't. So irrelevant information is going to increase the time and expense for your expert to do a file review and prepare your report. You don't need to necessarily give them the full disclosure package, but you need them to have all the relevant details about the offense and about your client, which may include them interviewing collateral contacts. It may include you providing medical records, things like the report to Crown Counsel, file summary, accused statement, statement of the complainant. It's going to depend from case to case. Something that can be helpful is to ask your expert to have an informal discussion with you before doing their full report. And you can sometimes save your expert time and your client money by doing so. They may go through the risk assessment process and say, hey, I'll be frank with you, your client is going to come back as being a very high risk. Do you still want me to write this report? And so you may be able to just get a very basic summary of their risk assessment, one-page letter to paper your file, and not expend all of that authorization that you had for all of those hours, because ultimately that cost trickles down to your client. On the other hand, there may be situations where either when you review the report or you have that informal discussion with your expert, some information is not helpful, but other information is. And so, of course, these experts are still witnesses. We can't try to influence their testimony, although we can always ask if we think that they have missed something or misunderstood something or don't understand how they reached a conclusion. But you may be able to hive off a portion of information that is helpful. So, maybe the risk assessment is unhelpful, but their discussion about your client's moral culpability is very helpful. And so you can say, can you just do a report speaking to moral culpability? As Katie mentioned, if you get back a negative report when you're retaining an expert as defense counsel, you don't have any obligation to, obviously, to disclose that to the Crown. But of course, if you do decide to put an expert up on the stand, you'll have that expert notice provisions and notice that you have to comply with. And it's helpful to have a discussion with the Crown once you get your report. If you decide you're going to use it and call the expert, ask the Crown for their position on qualifications, on whether they actually need to come and testify, because it's an additional authorization request and expense for the expert to actually come to court. And so sometimes the Crown may be willing to rely on the report if it's an expert they're familiar with that they know is generally credible. Katie, do you have anything else to add?
No, I think maybe we'll just jump to we had a few kind of resources for you. I know there are probably some other questions, but just a few resources here, forms to access to sort of get at some of the information that we've talked about today, as well as some textbooks and information you can find at the law library that provides helpful information. And also just want to note that if you do have questions about specifically Ian's video or auth requests in general, that's the email, the roster relations email is who you should contact to follow up on any questions you may have there. So I think I'll leave it at that unless you have anything else, Tania, and we can maybe take questions.
Sounds good.
Perfect. Thanks, guys. So we had a question / more of a question or comment from Darcy, just asking us to discuss disclosure requirements / privilege protection of the background information and communications that you share with your own expert, i.e. communications, notes, draft reports, the different types of matters. Are you guys able to provide any kind of comments on that?
Yeah, so I can start off. I mean, generally, when I write the letter of engagement to my expert, many of the experts that I deal with who have done this for a long time, they understand the confidentiality requirements. They understand they're being retained by defense. So we're under that umbrella of the litigation relationship, of the solicitor-client relationship. And so they're not going to go and disclose that information to other parties without the client's consent and without them being called as a witness potentially. If this is a new expert, you may want to sort of explicitly outline that in your letter, that you understand that this retainer in their report is being done on a confidential basis until you tell them otherwise. And so you certainly don't have any obligation to tell the Crown that you've sought a report in most cases. In terms of the background information shared with your own expert, and how that becomes disclosable when your matters are in court, certainly you have to provide a copy of the report to the Crown. I think the Crown would certainly be entitled to ask questions about the sources of the information of the expert in cross-examination, that sort of thing. I think it's obviously going to depend a little bit on the nature of your conversations and the nature of the case in terms of what could be disclosed. But if you don't call the expert, that information wouldn't go anywhere. Katie, do you have other comments?
I agree with that. And I think, I don't think that it's a situation where If you're having a conversation over the phone with your expert, that you're taking notes about these conversations, but you just want to make sure that you're always dealing in fact and you're not sort of veering off into opinion yourself, I guess. Like, you don't want to put your expert into a difficult situation where they're maybe under cross-examination from the Crown and they're having to answer sort of an awkward question where maybe they've been told something by you that wasn't appropriate or wasn't really relevant. So, this is a professional relationship, and it is important to establish sort of the rules of engagement initially with the expert. So as Tania said, you're setting this out in writing so that everyone is clear about what the expectations are. And that's so they're, ultimately, if they are on the stand under cross-examination, they're able to answer and articulate things in a way that is impartial at the end of the day.
And usually the expert reports will list their sources of information, and often it's material that the Crown already has because it's come from disclosure. So
exactly.
I see other questions about a list of experts, and I agree it would be really helpful if there were a list of experts that work at Legal Aid Rates. Unfortunately, I think right now we don't have that, so we just have to rely on our colleagues as best as we can.
Yeah, exactly.
Perfect. Thanks, guys. I know we're 1:17, so we're already a little bit late. So I just want to say on behalf of Legal Aid, thanks to Katie and Tania for taking time with us today. And then thank you for everyone for joining over the lunch hour. So as we mentioned at the start, a copy of the slide deck and a link to the recording will be shared with attendees tomorrow. And then for all news on future webinars and events through Legal Aid, just keep an eye on your roster report, which will go out typically the second last Thursday of the month. And that will link you to any new events that we have announced. So again, just thank you guys for joining us, and we look forward to seeing you next time.